Good evening, everybody. It's a pleasure to be here today and share some information about these services. It's something that's going to be coming up for discussion at a lot of IEP meetings in the next few months. So as I said, I'm really excited to be able to share this information with you all. There we go. Just had to switch the slides over. So as Love said, my name is Carrie Chilton. I'm a staff attorney with the Disability Law Center of Virginia. And a lot of my work focuses on special education, both in the community and at facilities. The Disability Law Center of Virginia is Virginia's protection and advocacy system. Each state has one. We're federally funded. And we do a lot of different things. So we provide individual advocacy services to families and adults with disabilities, as well as children with disabilities. We have systemic advocacy initiatives and projects that we do to work on policies and system change in Virginia. We also do rights and informational trainings for advocates and families and individuals, so that they're more aware of services that are in Virginia, as well as what their rights are on a variety of different topics. One of the really amazing things about the work we do is because we're federally funded, we don't have any charge for the services we provide, which is something I love about the work that we do. Before we get started on our topic today, I do want to mention, I know Love said that we will have an opportunity for answering questions, which is wonderful, and we're going to have an opportunity to answer those general questions. Now, if you have questions specifically about your family or your child or a child that you know personally, more of those specific circumstances, those are going to be better addressed with PT directly or by calling the Disability Law Center of Virginia. And at the end of my presentation today, I'll have that contact information. We're only able to answer general questions today. We can't give legal advice or answer more specifics, but you will have those resources available to you if you want to have more direct assistance after tonight. So we have a pretty full agenda today. I'm going to start by talking a little bit about where we are now and what a lot of students with disabilities are facing as we reach the end of the school year and schools are returning to in-person learning. I'm going to start then by talking about compensatory education. We'll move on to talking about extended school year services, or ESY. Then we're going to talk about COVID recovery services, which is really new and emerging and changing. So I'm very excited to share, the information I have with you on that. And finally, we're going to wrap up by talking about some advocacy strategies. So if you, for your own child or for a child of a family that you're working with, if you are trying to request one of these services that we talk about today, we're going to go over some strategies to help you navigate that. So where are we now? A little over a year ago, when the pandemic started, schools closed down in the spring. And during that time, they were still required to provide a free and appropriate public education once they opened back up and were providing those virtual services. The former Secretary of Education, Betsy DeVos, declined any waivers of IDEA, which is the Individuals with Disability Education Act. For those of you who don't know, that's the federal law that governs the rights students with disabilities have. And so there were no waivers of that act. And similarly, the Virginia Department of Education did not waive any of Virginia's special education regulations. So while things looked different in a lot of ways, all those obligations that schools had, especially to provide a free and appropriate public education, were still in place from the beginning of COVID throughout this duration of this pandemic. So what did instruction look like during this time? As I said, it looked very different than what it did before COVID. It also looked very different across the Commonwealth and within school divisions. It even looked different between high school and elementary school, how schools addressed teaching children. Some of those differences included when hybrid learning started, when return to complete in-person learning started, Some school divisions had periods of increased cases and they had to return back to a more virtual setting. Different divisions had a variety of use of teletherapy for speech, occupational physical therapy. Some of those were provided by the school staff directly. Some school divisions contracted with outside parties to provide those services. How paper packets may have been used in instruction. A big thing that we saw at DLCV that varied depending on where in the state you were was the availability of internet access and the provision of computers. That was a very big issue in the beginning of the pandemic, was how do we get computers to students who don't have them? How do we get internet connection to areas where that's generally not available? And then finally, some school divisions had additional supports and services such as small groups or one-on-one time with special education staff during virtual learning to assist students. So all these things looked very different, again, among school divisions and even within school divisions. Now, almost all the school divisions across the Commonwealth are returning to some form of in-person learning, whether that's hybrid or complete in-person, or complete in person for some students and virtual for others. And during this time, this year and a half or so, many students either faced gaps in educational services while schools were working to get those services in place, or were simply unable to benefit from learning due to these changes in instruction. The way that instruction could be provided was not in a way that a student could benefit at times due to that student's disability. Some students made some progress, but not sufficient progress compared to their peers. Some students made no progress. And unfortunately, for some kids, they've even regressed because they haven't been able to access learning and they haven't been utilizing those skills that they learned. So now that schools are returning to in-person learning, schools and families have to determine, well, this is where we are now. How do we move forward? And for those kids who need to be caught up, how do we provide services and supports to get that progress moving? Some students are going to need additional supports across all parts of the curriculum. Other students may need very specific supports, such as additional occupational therapy. So it's really going to look different. This is going to be a common theme you hear from me during our presentation today. It's really going to look different for each student based on their needs and what's available in the school division. So the time is now. Summer break is coming up quicker than we can even think about it. And this is a really vital time to get these services that we're going to talk about today in place for students who need them. For many students, tacking on additional services at the end of the school day or trying to squeeze them in during the school day are going to overwhelm students, and they're going to have limited benefit from those services. However, in the summer, there's much more time to be able to devote to catching these students up. In addition, now is the time where schools are going to need to plan for staffing, services, supports, because unlike in prior instances where maybe there's a couple of kids who need to be caught up for various reasons, we have a large group of children who have faced gaps due to this pandemic. So schools are going to need to be prepared on a larger scale to meet these needs. So talking about it now gives schools and families the time over the summer to make sure everything's in place for next school year. And then finally, a lot of learning occurs through building on those base knowledge and skills. So if we're not recouping knowledge now for these kids, they may have difficulty learning those new skills when the school year starts. So this is a really relevant topic now, and it's something that if you think your child needs some of these services we're talking about today, now is a really good time to start bringing that up with the school and having those discussions. So our first topic, we're going to talk about compensatory education. We're going to go over a couple of basics. So what is compensatory education? It's basically educational services that are provided when there has been a denial of a free and appropriate public education. Now, most families who have been in special education for a bit have heard of that term and kind of have an understanding of that term. For those of you who don't, we could talk about it for an hour on its own. There's a lot of case law. We won't get into the legalese of it today that interprets what that means, but the basis is that schools are providing supports and services and curricula that's appropriate for that individual student's needs, and that there's supports and services that meet those needs. And then again, that it's appropriate. So for some students, they may need even higher curriculum because they're twice exceptional. So they're gifted, but they also have a disability. So it's meeting all those needs. It's a whole picture, and it's very fact specific based on that student. And the purpose of compensatory education is to place the child in the position they would have been in if the appropriate supports or services were provided initially. So compensatory education is going to occur where there's that denial of faith. There was not a free and appropriate public education provided. And the whole purpose in determining what compensatory education is going to be provided is what's going to put that child back where they would have been if this didn't happen. So who could be eligible? Well, compensatory education applies to both IDEA and Section 504 eligible students. So even those students who don't have an IEP but have a Section 504 plan could be eligible for compensatory education. And it can come up in a number of different situations. A school could improperly deny a student eligibility under IDEA or Section 504. And then later it's determined either by the school or through dispute resolution, such as a due process hearing. Maybe a hearing officer decides that that student actually was eligible. But then there was that gap in time between when this concern was first brought up and eligibility was actually found. So compensatory education could be awarded to remedy that gap. Similarly, if there was a delay in the finding of eligibility or the initial provision of services, and the school's responsible for that delay. So for example, under the Virginia regulations, there was a very specific timeline, a number of days in which a school needs to, once they determine they're going to go through the eligibility process, evaluate a child and then meet to determine whether or not the evaluation shows if they're eligible. There's a very specific timeline for that. Now, if the school delays it, kind of puts it off, and doesn't evaluate the student for maybe a year versus the timeline is 65 days. Then in that case, because of that additional delay, there may be compensatory education awarded. Similarly, if the school is slow to put maybe additional services such as speech therapy in place once a child is found eligible. Another time when compensatory education may be awarded is if the school fails to provide all the services outlined in a student's IEP or 504 plan. Both of those plans are really distilling down onto paper what the school and the IEP team, which would involve the family, has determined is necessary for the school to either follow its obligations under Section 504 or for IEPs under the IDEA. So when a school doesn't provide those services in those documents, then they're not fulfilling those obligations under those laws. And that could be, again, a time where compensatory education is awarded to make up for that. Then finally, maybe an IEP or 504 plan was followed exactly, but the plan itself was not sufficient to provide FAPE. So maybe the IEP team failed to recognize that there was a speech therapy need. And so there was no speech therapy in the IEP when there should have been. Maybe compensatory education would be awarded for the speech therapy component in that case. So there's a lot of different scenarios in which compensatory education could be awarded to help, again, put the child back in the place they would have been in if those services were provided at the time they should have been. So how can a family go about receiving compensatory education for their child? Could happen at the IEP or 504 team meeting. And that's something that, you know, when we go over our advocacy strategies later on, we always recommend starting at that lowest level. Your relationship with the school, with the IEP team or the 504 team is going to be continuing over years. And you want to have a good collaborative relationship, and you want to have good open communication about what's going on. So if families have concerns that there may be a need for compensatory education, going to that IEP or 504 team to discuss that is a good place to start. Mediation is another option. I'm just going to list these due process dispute resolution options. We could talk about these for hours and hours, so I won't go over the ins and outs of each. But there is information on VDOE's website that talks about these, and the school also provides you information about your dispute resolution options as well. So mediation is an option. You could file a state complaint and request compensatory education, due process. These are all the state complaint, mediation, and due process are available for IDEA, IEP students. There could be a school level 504 due process or grievance process that would be available for 504 students. OCR complaint is also available for those being served under Section 504. And then finally, families could file a lawsuit. There's exhaustion requirements under IDEA, so you have to go through that due process first. 504 students, there isn't that requirement because there isn't a due process option available for Section 504 students. So again, families have a lot of options, and it could be as simple as going to that IEP team meeting and just discussing what's going on to get that resolution and that award of compensatory education. So compensatory education is what's called in the legal world an equitable remedy. And I could have made this slide very legalese and it would have glazed all your eyes over and you would have gone right to bed. But I am not here to do that to you all today. So we're going to break that down a little bit. Basically what an equitable remedy is it's focused on what's fair. So let's look at what happened and what do we need to do in fairness to make it right. So that means that a hearing officer, if it's a due process and a hearing officer is making a decision about compensatory education, they're going to look at the whole picture, look at what happened, where we are now, and what's going to be fair. So a court is going to see if there was a procedural violation. Did the school not do something they should have under IDEA or the Virginia regulations? And if there was a harm. So if the school maybe missed a deadline by a day, but it didn't affect the student's services, or the school didn't do something else they had to do, but it was over the summer, so the student wouldn't have gotten those services during the summer anyway because they weren't eligible for summer services. There was no harm. So in fairness, there's nothing to make up. So in those cases, a hearing officer or judge may not award compensatory education. Similarly, if a child has already caught up, maybe the school, the child was behind, there was a harm, but the school's provided some extra tutoring or services already, and the student's already where they would have been even if that gap hadn't occurred to begin with, then compensatory education may not be awarded, or it may be reduced if the student's caught up a bit but isn't fully where they would have been. And then finally, if parents are partially responsible for that denial of FAPE, so for example, they maybe refused to allow an evaluator to evaluate their child or did not consent to services, in those cases, a hearing officer or judge may reduce the compensatory education award or could deny it. Again, they're going to look at the whole picture and determine what's fair. So what does compensatory education look like? Really depends on the child. This is another point where I said it's very individualized. It's going to be based on what services were not provided and what the student is going to need to catch up. Could be small group or one-on-one services. Hearing officers and judges have different ways of looking at this when determining the amount of services. Sometimes they'll do an hour for hour or day by day. So if you miss 10 hours of speech therapy, you'll be awarded 10 hours of speech therapy. Sometimes, however, they'll adopt what's called a qualitative standard. And this kind of goes back to our notions of fairness, right? If hour for hour doesn't really make sense, then the student may have different hours awarded in compensatory education than what they missed. So an example here that may come up is, say the student missed, they didn't get the support they needed in the classroom setting. And so they weren't able to progress the way they should have. And then the compensatory education that's going to be awarded is going to be one-on-one. Well, one-on-one looks a lot different. A student may be able to catch up and progress quicker in a one-on-one setting than the classroom setting. So the amount of hours awarded may be different than the amount of hours the student was in that classroom without supports. The school could provide these services directly. They may contract with a third party. They could provide the family with reimbursement for privately provided services. Again, it's going to look different depending on the circumstances. The school may also have to provide what's sometimes called tuition reimbursement or reimbursement for other services that the family paid for during that dispute resolution process. So things like mediation, due process hearings can take a bit of time, and sometimes families are able to pay for the student to get services outside of that public school setting during that time. And if it's later found that the school really should have been providing additional services, then they may be required to pay the family back for that. Really interesting fact here, which if you think about it, makes a lot of sense. Compensatory education can continue even when a student has surpassed the age of special education eligibility, so they've turned 22, or they've moved out of the school division. And again, this makes sense because you don't want schools to maybe fail to provide services, and then there's a delay in coming to a decision that the school should have provided those services, but the students moved or the students aged out, and now we can never make up what was lost. Again, going back to fairness, it makes sense that even if a student has aged out of services or has moved, that the school may still be responsible for making up for that gap. So we've talked a lot about compensatory education, and now we're going to talk about something much more specific, which is extended school year services, or ESY. So these are services that are provided to a student outside the standard school day, most often provided during summer break, because that's often the longest break in the school year, but it can also be provided over other holidays outside of the normal school schedule. The law says that this cannot be limited by type, amount, duration, or category of disability, which basically means a school can't say, well, for all students who have autism, they automatically get this autism ESY program, and they don't get any other programs. They're not eligible for any other ESY programs. Again, it has to be meeting the individual needs of that student. Section 504 does not specifically talk about ESY services, IDEA does, but the Office for Civil Rights that interprets Section 504 has interpreted Section 504 as requiring that same application of ESY. So the rules that we'll talk about today regarding ESY are going to apply to Section 504 students as well. So who's eligible? The question schools have to ask is, will progress made during the school year be significantly jeopardized if the student does not receive ESY? In other words, is ESY necessary for the provision of FAPE? Again, we've got these kind of vague, very broad terms that are going to apply very differently depending on each situation. But basically, is it necessary for the student to continue progressing as they should, right? VDOE talks about specific key factors that schools need to look at. What's the risk of regression? What's the ability to recoup any lost skills? What was the degree of progress during the school year? Are there emerging skills as we approach the end of the school year? Are there behavior needs? What's the severity of disabilities? And then they say other factors. So again, it's really that whole picture approach. IEPD and 504 teams do not have to wait until regression occurs to find a student eligible. So that's really important. If we've got a kindergartner who's about to come across their first school summer break, they could be eligible for ESY, even if they've never had a summer where they've regressed. When there's that risk of regression, but there hasn't been actual regression and there's no data to show that a student would regress, you can show a risk of regression by looking at data during the school year, maybe over Christmas break, or expert assessments. So there could be an assessment that shows, the student hasn't regressed yet, but based on their needs and their disability, they're likely to significantly regress over the summer. Regression that is at risk has to be more than the regression all students suffer during extended school breaks. So we know that all students, and it varies in degrees based on how old the student is, will lose some skills over long breaks, especially the summer. So a student with a disability to be eligible for ESY services has to have a risk of greater regression than their non-disabled peers. So what do extended school year services look like? Again, individualized. Compensatory services are much more likely to be one-on-one because it's that individual child who has that need. Whereas extended school year, there's generally a group of students within the school who will need extended school year services. So that's more likely to be provided in a programmatic or group setting. Can be for all of the school break or part of the school break. It could be less frequent than the school schedule. So maybe you only need speech ESY services, and that's only an hour a week. Or maybe you need it across, your core subjects, but you just need like half a school day, 3 days a week over the summer to prevent that regression. Again, it's going to be based on what that student's needs are. As I said, it could be focused on a particular school subject or therapy, or maybe a particular IEP goal. Again, very individualized, and it must be appropriately tailored to that need to ensure that FAPE is provided. So IEP teams should be meeting and not only identifying if a student needs ESY services, but why they need it and what those services need to look like to provide FAPE. So where are ESY services provided? It doesn't have to be in the same placement as the school year, because school programming over the summer, those options look very different than they do in the summer. However, least restrictive environment requirements still apply. And for those of you who are not familiar with that term, basically, least restrictive environment requires that to the extent necessary, students with disabilities have to be educated with their non-disabled peers or with other students. And if that means that additional supports and services have to be provided in that general education classroom, then that's where that student needs to be served. Schools can't simply remove a student from a general education classroom because it's more convenient to provide one-on-one services instead of providing those supports in that classroom setting. So this still applies. So if a student could attend, maybe there's a summer program that's available to students without disabilities as well, and those ESY needs can be met in that program with an aid, then that student needs to be going to that less restrictive program. A lot of schools have their own programming. Sometimes schools will place a student in an ESY program that is through a separate, maybe another school division or a private school or a private entity. Even if a school does provide their own programming, they may still have to send a student to another ESY program if the student's needs can't be met in the local program. So maybe a student has a very specific extended school year service need to provide to receive FAPE. In that case, if the school can't meet that need, they may need to find another location that does meet that need. And especially in those cases, schools have to provide any related services, including transportation that's necessary for the student to access that program. So we talked about what ESY is, but ESY is also not a few things. So ESY is not summer school. ESY services may be met through a summer school program with additional supports. Again, it's going to be based on what's required for FAPE, but just putting a kid in a summer school program does not automatically mean that a ESY obligation has been met. ESY is not compensatory education. ESY factors for eligibility for ESY look completely different than compensatory education, which again results from a failure to provide FAPE. For ESY, there hasn't been a failure to provide FAPE. You need ESY in order to continue providing FAPE. And ESY is also not, we haven't talked about this yet, but spoiler alert, COVID recovery services. That's also different than ESY. So as schools are having these conversations, they're going to be having these conversations about all these services, maybe at once for some families and some students. Some students may need ESY, maybe they have needed it in the past, maybe it's their first time eligible for ESY services. They may also need some COVID recovery services this year. Those conversations are all going to be happening now. And it's really important for IEP teams and families to keep in mind that a student who is eligible for ESY based on those factors we talked about, like risk of regression and emerging skills, should receive ESY in addition to compensatory education or COVID recovery, because all of these services come from different needs. So really make sure you're having a full discussion with your IEP team or 504 team about these different services, whether or not your child is eligible for each of them, and how you're going to provide under each of them separately. So the moment, at least I've been waiting for, and I'm very excited about, and hopefully you all are too, because again, this is a really emerging, ever-changing discussion that's going to be coming up in the next few months, if not now, at a lot of school divisions, is COVID recovery services. So I'm going to talk a little bit first about the federal level guidance. Now, I will say that COVID recovery services is a term that the Virginia Department of Education, VDOE, coined last year. The federal government has not used that term and has not used any sort of novel term to refer to services to make up for gaps in education due to the pandemic. They just call it compensatory education. So that's just something to really be aware of as you're reading things, that the federal government may call something compensatory education that Virginia would consider COVID recovery services. So in March of 2020, right at the beginning of the pandemic, the US DOE issued a COVID-19 question and answer document that provided some guidance to schools. When the school is closed to all students, the school division is not required to provide services to students with disabilities. So that's really important to keep in mind. During those complete school closures, there wasn't an obligation to continue providing speech, for example. But when services are being provided to any students, a school must make every effort to provide the services outlined in a student's IEP and 504 plan, and ensure that students with disabilities have equal access to the programming provided. And that language of equal access comes from the ADA. So the federal government, right from the beginning, made very clear that schools need to be doing what they can to provide the services that they were providing before, even if that may look different, and continue to provide FAPE to students with disabilities. This document did acknowledge that exceptional circumstances could affect how a service is provided. So for example, speech therapy may be provided via teletherapy. And in these cases, the IEP team had to determine if compensatory services were warranted. So when we deliver these services in a different way, does that still provide the student with FAPE? If it provides the student with some benefit, but not sufficient benefit, maybe there's compensatory services that we're going to have to make up when we're able to. So that's something that this document specifically addressed. And then a couple of more specific scenarios here that the question and answer document talked about is if a student had COVID-19 and was out of school for an extended period of time, the IEP team has to determine if the student could benefit from some sort of homebound instruction. And if they didn't receive services for a long time due to this, the IEP team again had to look at compensatory education. And then there was high-risk students. So students who may not have COVID, but if they got it, could have a high risk of a very detrimental effect or have a high risk of catching it. And here they looked at long-term and short-term exclusion from school. And I won't get into the nitty-gritty of that, but if it's 10 school days or less, the school had to try to provide some services, but it wasn't considered a change in placement. Whereas if it was going to be more than 10 school days that those high-risk students were out, then it would be considered a change in placement, which would require an IEP team meeting, for example, the parent to consent to that change of placement, just more detailed discussion about that if it was going to be that extended absence. So now we're going to talk about the state level. Around the same time, a few months after, probably about May or so of last year, the Virginia Department of Education issued their own guidance on what they called COVID recovery services for students with disabilities. They define this as services offered by Virginia school divisions to address a loss of services during COVID-19. And they clarified that this could be even if a school was not at fault for those loss of services. If the school did everything they could, they went above and beyond, they tried 10 different things to make virtual learning accessible for the student, and it just wasn't possible. Those students could still be eligible for COVID recovery services. In addition, the guidance issued by VDOE said that during this time, during the pandemic, a student could also face a denial of FAPE. And in those times, the standard compensatory education determination would be made. So they've kind of made a distinction between when schools are maybe not at fault versus when maybe the school could have provided a service and they didn't during the pandemic. COVID recovery services also include services that are needed to recoup previously learned skills, as well as new services that are needed to support a student's transition back to school. So a good example for this would be, the pandemic is obviously a very traumatic experience, and some kids may have new or different mental health needs. because of what they've been through over the last year and a half. So those services don't really fall into that category of traditional compensatory education, but they would be a new service that would fall under the definition of COVID recovery services. Similarly, social emotional needs, social skills, learning, all those things may be different services that students with disabilities need, having been through this pandemic over the last year and a half. VDOE clarified that this does not have to be a minute-for-minute replacement of services. The focus should be on what the student needs to recoup that lost progress. So, what's the difference between COVID recovery services and compensatory education? We kind of touched on this a little bit on the last slide, but it's kind of hard to conceptualize. Certain situations can clearly fall into one or the other, and some are more in this gray area. So I wanted to tease this out with you all a little bit more. Again, COVID recovery services can be provided even if it was determined that there was not a denial of FAPE. So even if a school provided a free and appropriate public education, if that student didn't progress as they should have, or maybe they did progress as they should have, but now they have an additional mental health need in the school setting because of COVID, then COVID recovery services could be appropriate there. And then compensatory education can be awarded, this is the VDOE guidance that states this, if services needed to ensure FAPE were so complex and as such could not be reasonably provided through a virtual learning platform or other alternative needs that were available. So VDOE seems to make a distinction between was FAPE provided or not as to whether or not it's considered a COVID recovery service or compensatory education. Again, compensatory education is going to be based on that failure or inability to provide FAPE, placing the student in the same position had that not occurred. And additionally, here the guidance states that parental or student's decision not to participate in that voluntary educational opportunities. This was more last spring as schools opened back up. There was a lot of voluntary work that students could do that didn't go towards grading. If a parent or student chose not to participate in that, then that's not considered a denial of FAPE. Now, I will take a moment here just to say that, again, this was issued close to a year ago now. And while, there is word on the ground that VDOE may be issuing additional guidance on COVID recovery services or in general, how to meet the needs of students with disabilities as this return to in-person learning continues into next school year. There's been no firm timeline for if that will be issued, when that will be issued, what that will discuss. So we're really working on this guidance document from last year. And I think a lot of schools and families are trying to figure out, well, how do we navigate this and what does this look like for this particular student or that particular student? And how does this look like for my child? And that's something that we're all gonna kind of navigate as we move through it over the next few months. So who will be eligible for COVID recovery services? Again, individualized determination. And the focus here is going to be, has the student continued to make progress in their curriculum towards meeting their IEP goals? So both in classwork and towards IEP goals. Has regression occurred during distance learning? How is the student performing now that they've gone back to school? And this progress is going to be measured as compared to other students. So there's a general understanding that all students may not have progressed the same as they would have if we were in-person learning all last year, but if there are certain students who progressed even less or did not progress at all compared to their peers, those are going to be the ones who are eligible for these COVID recovery services. So, does every student with a disability, do schools have to provide a meeting for each of those students? The answer is no. Schools are not required to hold IEP meetings for every student upon returning to in-person learning. There's a few factors that they should look at and consider when determining whether or not a particular student they may need to meet to discuss these services. And these factors include when there's a lack of expected progress towards annual goals, or again, that general curriculum. If they've collected some data to see if a student needs COVID recovery services, then VDOE says, well, you need to meet to discuss that data. The results of any reevaluation conducted, or any information that's shared by a parent or teacher that may suggest there's a need for that COVID recovery service. And then finally, just generally, if school anticipates that a student may need these services, even if they haven't formally collected data to determine that, they should be meeting to determine if there's going to be data that should be collected or if COVID recovery services should just be provided and there's enough data already available. So we just kind of talked about what schools need to be looking at when determining whether or not to hold a meeting to talk about COVID recovery services for a student. But what if a family's identified? What if you've identified that your child may need these COVID recovery services? You know, parents have been in a very unique position this last year and a half. You all have really been able to see how your student is doing, your child is doing in a way that teachers may not be able to, and you have really valuable data and input. So if you think your child needs COVID recovery services, you can request that of the school. And VDOE's guidance says that when a parent does that, this is treated the same as a request for an IEP team meeting. Very specifically, VDOE has said that the school should respond to that request within 10 business days. Now, a meeting does not have to be held within 10 business days, but the school needs to respond to that request within 10 business days. If the school denies the request, says, you know, I don't think the student needs COVID recovery services, prior written notice needs to be issued, and we'll talk about that in a few minutes. The school may request time to gather more data. Maybe they need to do a little bit more evaluation. Maybe they need to talk to the teacher about what's been going on to determine if COVID recovery services are something the student needs. If they do that, if they make that decision, the school needs to specify the amount and types of data needed. And this is a place to really make sure you have a good specific understanding of what the school is going to be looking at and how long they plan to take to gather that data. To make sure the ball's moving forward and everyone's on the same page in regards of what we need to look at to determine if COVID recovery services are needed. Schools should be looking at progress data from before COVID to see where the student was at, that baseline before the pandemic, during COVID to see if the student was progressing or regressing. And then return to school instruction data is really important too. That's going to show how quickly we think the student may be able to catch up and make up for any of those gaps in services that they faced. These are all things that should be reviewed and looked at when making these decisions. So, data sources. Data sources can include a lot of different things. Again, parents, you guys are in a really good position to provide information about what was going on during virtual learning. Also, progress notes through IEP goals, objectives, and benchmarks. Observations from teachers, service providers, this is all important data. Testing data, student work samples, behavior logs. There's a lot of different sources of data that is already available that you as a parent can provide or the school can pull together to determine what may be needed if it's determined that COVID recovery services are appropriate. So the school's made the decision, yes, your child needs COVID recovery services. What do you need to do at that point to make sure that it's documented? You want to make sure that this is documented in your child's IEP or 504 plan, and very specifically and as detailed as you can. So specifically the scope, what kind of services are going to be provided, when they're going to be provided, how often, in what setting, and how is that for an hour every week? How is that for 3 months? Really all the details of how it's going to be provided, because you want everyone again on the same page regarding what is needed to recoup this loss of services. And if we're getting towards the end of the COVID recovery services that were originally agreed on by the IEP team, this student may need some additional COVID recovery services after that. And if that's the case, the IEP or the 504 plan can be amended to extend those services or provide different services or additional services. Again, students' needs are ever changing and emerging, and things can change, right? So we want to make sure we're continually checking in and having that conversation and updating things as needed. What do COVID recovery services look like? As we talked about with compensatory education and ESY, it's going to be individual based on the child's needs. Least restrictive environment applies here too. Schools can really get creative about this. Are we going to change the school schedule? Are we going to do it before school, after school, over school breaks? Again, all these details are something that should be discussed at the beginning with your IEP team or 504 team, and a detailed plan, really thinking through all these things, should be made at the onset. So what happens if you, as a parent, and the IEP team or 504 team just can't get to a decision on what's appropriate regarding COVID recovery services, whether or not a student is eligible, and if everyone agrees that that child is eligible, what those services look like? This can be considered a denial of FAPE, and those dispute resolution options we talked about earlier with compensatory education are going to be available in the same way that they are for compensatory education. So we won't go through those all again, but just know that those same options would be available if you and the school are just unable to come to an agreement on what COVID recovery services should look like for your child. Again, a lot of times discussion through an IEP meeting and open communication can really resolve a lot of those things, but if not, there are those dispute resolution options available. So we're gonna very quickly go through a little quiz for you guys. Hopefully it's not too late in the day to wake your brains up for just a little bit, but I wanted to provide you all with some examples of students who may need one of these services to help you understand a little bit better about the differences between these three. So we're going to go through some hypothetical situations here. And in a minute, once I read through this, we're going to post up a poll so you all can participate. I promise the answers are anonymous, so no pressure, guys. But I want you all to use your brains a little bit to see if you can kind of sort out the differences between these services. So our first scenario here, Susie is a student with ADHD. Prior to COVID, Susie had a classroom aide who helped Susie focus and stay on task. The aide would redirect Susie when she went off task during school day. During virtual learning, the school assigned an aide to work with Susie virtually. The aide is in the classroom setting, on the screen, talking to her via chat, kind of keeping an eye on her in the video stream. She also has one-on-one sessions a few times a week to work with Susie and try to get her through some of her more independent classwork. The aide has a ton of different attempts to try to redirect Susie. Again, video streaming, chat function. Susie's just not able to regain focus. She's often moving around her room and getting up and walking away from the computer screen during class time. The school's tried other things. They've had teacher check-ins. They've had even the teacher, not just the aide, send Susie a little chat message saying, "Hey, Susie, I see you. I see you're looking over at the corner of the screen. How are you doing? What's going on?" And they haven't been able to find a solution that keeps Susie focused. And as a result, during virtual learning, Susie's grades have suffered. So we're going to pop up the poll now, and I want you all to think, what is the most appropriate for Susie? Compensatory education, ESY services, or COVID recovery services? And then those answers can be posted whenever it looks like we've got enough people who have answered. Okay, COVID recovery services looks like it is the winner. Let's go to our next slide here. 1 second. And yes, that seems under these facts. Again, we don't know all the facts here, so we can't make a sure determination. But it seems like COVID recovery services would be appropriate for Susie. The schools implemented Susie's IEP. They provided the aid that's in her IEP. They even tried some new services and supports. It sounds like they really did what they could to make virtual learning something that's beneficial for Susie. Now, this is assuming that in-person was just not an option during this time. It seems like the school took all the steps they could to provide FAPE, but Susie just wasn't able to make that progress. So virtual COVID recovery may be a good fit for Susie. Okay, next scenario. So Steve is a student with traumatic brain injury. He's been able to fully access his virtual learning. He's been making progress all school year. He is doing great. He's acing it. Steve's TBI affects his ability to remember things and recall facts and content. He learns best when things are repeated over and over again, and also when he can really practice those skills continuously. He often forgets learned skills when he doesn't have an opportunity to regularly practice them. So we're going to pop up the poll here again. And what's the most appropriate service for Steve? Extended school year services. Yes. Good job, guys. So it looks like Steve is going to have some regression of the skills over the long breaks if he doesn't have opportunities to practice those skills. It doesn't seem like it's really pandemic related or COVID related. He's doing great in the virtual setting, but he may need some ESY services over the summer. So his IEP team should meet and discuss what those services should look like to give Steve faith. Okay, next scenario. Sam is a student who has a hearing impairment and needs speech-to-text software installed on his laptop so that he can access virtual learning. The IEP team has agreed, yes, he needs speech-to-text to be able to access virtual learning. The school tells Sam's mom, yep, we're purchasing it, we're gonna install it, we're gonna get it all set up. Takes 2 months for the school to do that, and during that time, Sam was not able to access the virtual learning environment. So we're going to pop up our poll here again. Which service is most appropriate for Sam? Ah, 100% compensatory education. Good job. I am glad that I was able to explain these very dense subjects to you all today. That is correct. The school, it sounds like in this case, it wasn't due to the pandemic. They just didn't provide the speech-to-text software in a reasonable time. There wasn't a reason for the delay. They just kind of didn't get to it. Sounds like there may have been a denial of faith here. And in that case, the traditional compensatory education would apply, and they would need to determine, well, how do we make up for those 2 months that Sam couldn't access the virtual learning? So our last part of our quiz here, we have Sabrina, who's a student with autism. She struggles with verbal communication, but she started working with a new speech therapist in June. She's been making strides. She's doing great. The speech therapist has noted, hey, there's some new skills that are developing here. I'm really excited that I can see Sabrina really developing these speech skills. She's doing great. She wants to continue working with Sabrina to make sure these skills get fully developed. So again, let's pop up our poll here for the last time. What would be the most appropriate service for Sabrina? A 100% extended school year services. You guys are amazing. Yes. So we're at the end of the school year. Sabrina has these newly emerging skills. That's one of the factors. If we're kind of halfway through learning a new skill and we stop, we're probably not going to be in a great place to just pick up after the summer, right? Sabrina's speech therapist recognizes this as well. She wants to keep moving. Likely these ESY services would be very specific and focus on speech therapy. And again, that would be her IEP team who would get together to determine what that would look like and how often that would be provided. So we're going into our final section here today. We're going to talk about some advocacy strategies if you as a parent are looking to request one of these services for your child, or you're an advocate looking to request these services on behalf of a child that you're working with. So the first thing is stay updated, right? Especially with COVID recovery services. As I said, we are waiting to see if VDOE issues more guidance on COVID recovery services. Could happen at the federal level as well. So Again, these slides are going to be provided to you all, but here's links to just the general pages for both VDOE and the USDOA, so you all can stay on top of these guidance documents as they're issued and as things change or are clarified. So the first step to advocacy is data, data, data. You as parents, again, are in this unique position during virtual learning to really see what's going on. Try to track any concerns you have or things that are working really well too, right? You want to make a note of what's working as well as what your child may be struggling with. If you have a notebook, Excel sheet, whatever works for you, try to jot down any of those, really great things and concerns or needs that you're seeing. Try to be as specific as possible. How often is this occurring? What's occurring? Why is it occurring? Why do you think it's occurring? What's going on here? And try to do that contemporaneously. If you can just jot it down in the moment, if you have something ready, a place to put that information, that's gonna be a lot more fresh in your mind than trying to think about what happened 6 months ago. So to the extent that you can start keeping track of that data, if you aren't already, that can be really helpful to inform an IEP team to help make this decision. One thing about virtual learning that is great is that there's so much data already available. There's online learning portals, parent portals, emails that are going back and forth, emails and texts between teachers and therapists and families. And that all that information can be gathered and looked at and can really help inform an IEP team as to what a student may need and what their deficits may be. So really don't forget about all that really good data that's already out there. Don't just look at the academic data, those quizzes and those scores, but also any behavior data. So the academic data may show that your child isn't progressing the way they should, but keeping an eye on what's going on with behavior, if your child has a behavior-related component to their needs, could help inform why your child isn't progressing the way they should. So don't forget to just, not just look at quizzes, but also see kind of whole picture, what's going on. Is your child being able to focus and pay attention? Things like that. Consider how often services impacted learning and how severe that impact was. So how often did this happen and how much of an effect did it have? And again, you want to take a look at all this and see, does it look like your child's regressed, maybe made some progress, but not as much as their peers? Or if there was any kind of services that weren't provided during this time. Those are all things to look at when considering whether or not you may need to make a request for any of these services that we talked about today. I'm going to talk briefly about evaluations and independent educational evaluations. So again, as I said earlier, the IEP team may decide to conduct an evaluation to determine if your child is in need of COVID recovery services or compensatory education or ESY. This applies to all these things. And you may get that evaluation back and you may have concerns about either the way the data was collected or the conclusions that were made in that evaluation. Under IDEA, so this is for students with IEPs, if you disagree with the school's evaluation, you can request what's called an independent educational evaluation at the school's expense. So the school has to pay for that independent evaluation. The IEU request has to be the same type that the school conducted. So if the school conducted a psychological evaluation, you would be requesting a psychological evaluation. It has to be conducted by a qualified evaluator, someone who is qualified to complete that type of evaluation. Now, schools are required to provide you with a list of independent evaluators that you can use in your area, but you do not have to stick to that list. If you find somebody else in your area that you think is that you would prefer, who's qualified, you can use that person as well. If a school doesn't want to provide funding for an IEE, they have to win at due process hearing on the issue. So school can't just say, no, we're not going to do that. We think our evaluation was fine. They would actually have to file for due process and go through that hearing. And a hearing officer would have to say, yes, your evaluation was appropriate in order to have an independent educational evaluation request denied. Again, this is only a right under IDEA, so students who have IEPs. If a student has a 504 plan, a parent can get an independent evaluation, but the school is not obligated to pay for that. So a parent could go and seek that evaluation and bring it to the table for the 504 team to discuss, but a parent doesn't have a right for the school to pay for that independent evaluation. Now, VDOE did recently clarify that a parent's right to request an IEE is not limited to the areas of need that the school chose to look at within their evaluation. So say within a school's evaluation, a psychological evaluation, they didn't evaluate one specific area of need, and the parent, because the school didn't think that was an area of need, the parent says, oh no, this is definitely an area of need and we should have looked at this as part of this evaluation. When a parent goes and requests an independent educational evaluation, they can request an evaluation that encompasses that other area of need. So that's just a recent clarification that VDOE had made that parents should be aware of. Be specific when you're requesting any of these services. We talked about today, it's going to look different for each child. So you really want to make sure when you're talking about any of these services that you're talking about what subject areas or therapies need to be addressed. Is it going to be one-on-one, small group? Really important, what qualifications will the service provider need? You know, does your child need a licensed special education teacher to provide these services? Do they need a paraprofessional? Do they need someone who has certain certifications for behavior services? That's something that needs to be discussed. How many hours of total services will be provided? How often will they be provided? When are they going to fit into your student's schedule? That's another really important thing. Mornings may work better for some kids. After school may work better for some kids. Some kids cannot do extra time at the beginning or end of the day. Summer may be the only time that they're really going to benefit from some of these services. So that's something to talk about again with the school. Is the school going to provide these services directly, or are they going to contract with someone or have the parent go out and seek a provider and then the school's going to reimburse them? Again, these are all details that you want to make sure that you talk about in the beginning so that everyone's on the same page if it's been decided that one of these services should be provided to your child. What happens if you ask and the school says no, or the school says yes, but they disagree as to what exactly that service, you and the school disagree as to what that service should look like? Schools are required to provide that prior written notice that we mentioned earlier. Oh, 1 second here, getting ahead of myself. Whenever they deny a request for any of these services, and that would include a partial denial. Maybe they're saying yes, your child's entitled to some, but not the extent of what you're asking for. The PWN needs to outline really a summary of everything about that decision. What decision was made? What did we look at in making that decision? Why did we make that decision? Did we look at any other alternatives? And why did we either go with those alternatives, or why did we also deny those alternatives? It really should be a whole summary of what was talked about. Make sure that your prior written notice is complete and accurate. If for some reason you choose to go to, for example, a due process hearing, a hearing officer, VDOE, through the complaint system is going to look at those prior written notices to see what was discussed and what wasn't discussed. And if something's missing or isn't accurate, then that could affect the outcome of a dispute resolution option. If something is missing or inaccurate, you can ask for the school to amend that prior written notice. If the school refuses to do that, you can always submit a letter saying, you know, the prior written notice fails to address this, or it states this. However, when we discussed this issue, this is what was actually discussed, and you can request that that letter be included in your child's educational record. So that way you have something contemporaneous that's in writing that reflects your understanding of what occurred. Again, this is a really important document. And finally, you've got this prior written notice. You may be on a different page than the school with one of these things. You have those dispute resolution options. You may wish to talk to a lay advocate or an attorney to determine which of these you may want to pursue, or through one of those processes. They can be complicated. And so it's just something to consider, is you may want to reach out to a lay advocate or an attorney if you're thinking you may need to pursue a dispute resolution option. So we're wrapping up here. We're just going to talk about a couple of different resources that families have available to them if again, they think their child may need COVID recovery, extended school year services, or compensatory education, as well as if they're to the point where they feel like they've tried to communicate with the school and they're just not able to come to a mutual understanding of what your child needs. So there's some online resources here. We've got the links that will be available to you when this is sent out. Again, you've got the U.S. Department of Education, Virginia Department of Education. VDOE has a lot of resources on their website regarding, they've got their special education regulations. They have guidance documents geared towards families, as well as school administrators talking about various disability rights and regulations. They have documents on COVID recovery services. So again, those are two really good resources. The Council of Parent Advocates and Attorneys, they are a national organization that has membership of family side attorneys and advocates. And they do also provide things like fact sheets and informational material on topics, including the topics we talked about today. And in addition to that, they do have a directory of their members. These are advocates and attorneys that provide paid services for a fee of special education representation. So that directory is available on their website. The Legal Aid Justice Center is another organization we'll talk about in the next slide a little bit about their advocacy services, but they also have fact sheets on some of the COVID-related issues we've seen over the last year. Legal Aid Justice Center has also done a couple of short recorded videos that are available on their website and Facebook talking about virtual learning and learning during COVID and things like that. So Legal Aid Justice Center is, again, another resource for families that are looking maybe to read some fact sheets or watch some videos, get some additional information about these subjects. Finally, shout out here to PTSI. As I'm sure all of you who are on here know, PTSI has a wealth of knowledge. They have these live trainings like we're doing today. They have wonderful fact sheets that really break down these concepts into simple, digestible, understandable bits of information. One thing I love about some of PTSI's materials is they have like worksheets too, right? To help you think through, think about what questions you may need to be asking yourself, asking about your child in making different special education related decisions. So PTSI has a lot of great materials too on COVID related concerns, extended school year services, compensatory education, all that great stuff we talked about today. So live resources. We talked about kind of our online materials and fact sheets. The Virginia Department of Education has an ombudsman. Their sole job is to provide information and assistance in non-legal special education matters. So the ombudsman, and we've got their contact information on the other slide here, can answer questions. If you have a question, maybe you don't understand the VDOE guidance on COVID recovery services, maybe you don't remember how many, after I request a meeting for COVID recovery services, how many days is it that the school has to respond? I don't remember, and I can't seem to find it anywhere. Call or email the special education ombudsman and they can answer that question for you. Now, they cannot give you legal advice. They cannot tell you whether or not your child may be eligible for these services, but they can give you that straight information. They can direct you to different VDOE resources or possibly resources in your locality that relate to special education matters. Some local legal aid offices provide representation or informational assistance on special education. That's really going to vary by locality. And some of their services may have financial income maximums for eligibility, but that's something else to look into too and consider. DLCV, as I said, we provide individual services as well. We are able to provide direct representation in some cases, while the volume across the state of the need for these services far exceeds what we're able to provide in terms of direct representation. We do always try to direct families to information or resources that can help them, even if we can't directly work with them. So when you call us, we do try to maybe refer you to another organization or provide you information to help answer your questions that you may have. Finally, the Legal Aid Justice Center, which I mentioned just a minute ago, in addition to having some great fact sheets and recorded informational sessions, They do also provide advocacy services. And one subset of their services I just wanted to highlight here is the Legal Aid Justice Center does have a group of volunteer attorneys that are just attorneys across the state who have volunteered to want to help with special education issues specifically. And those attorneys, one of the issues that that program is focusing on this year is COVID recovery services. So families who have who are maybe seeking COVID recovery services for their student and haven't been able to advocate for that at that IEP meeting level, may be able to be connected to a volunteer attorney through the Legal Aid Justice Center, who will be able to advocate for those services. So I just wanted to highlight that there, as that is a topic that they are working on within that program this year. So we've got all our great contact information here. We've got the Ombudsman information. We've got information about when we have our intake specialist who is live at DLCV. And then there is the intake line for the Legal Aid Justice Center Youth Justice Program. And that's going to be the number you would call if you want to get connected to that volunteer attorney program for special education matters. And that is the end of our presentation today. I would normally say I hope you all learned something and took something home, but from looking at those quiz results, I know you guys did. So thank you so much for sitting here with me tonight and learning about these topics. And as I said, I was very excited to be able to share this information with you all.
Thank you so much, Carrie. That was great information. We do have a couple of questions. I know time is short, so I'm going to paraphrase some things to kind of put them in a couple of questions, and then I will say some people have put in questions that are more specific to IEP issues and not necessarily these topics that we've talked about tonight. So if your question does not get answered, again, please feel free to contact Pizzi. We are glad to work one-on-one with you to answer those, to make sure you get your answers. There's a couple of questions having to do with ESY and asking if ESY, I guess it's about the timing. A lot of people are saying that they are under the impression, or their county is sharing, that ESY is only for 1 month in the summer or a certain time in the summer. So can you share that information again around ESY and when it can occur?
So I think sometimes that confusion comes up because ESY, because it's something that a group of students will need every year, school divisions do tend to have ESY programs that may run a certain duration through the school year. Over summer break, and may look a certain way. But again, under IDEA, ESY has to meet the needs of that student in order to provide a free and appropriate public education. So if that program running for 1 month in the summer is sufficient to provide your child with FAPE, then the school does not need to provide it over the whole summer. But if that's just not going to provide FAPE to that particular student, then the school does need to look at, maybe the student will be enrolled in that program but receive additional services before and after, or maybe part of a completely different program. Again, it is very individualized.
Great, thank you. There's another question about if you could offer any insights about COVID recovery services, specifically for students who are aging out of school this year.
So that is something that VDOE has not provided specific guidance on. We do know that for traditional compensatory education, that even students who have aged out are still eligible for compensatory education. And I just want to remind everyone that over the course of this pandemic, there may be students who did face a denial of FAPE, and in those cases may be entitled to traditional compensatory education, which in those cases that aging out would not make a difference. But for students who may be only strictly eligible for that COVID recovery services, VDOE has not specifically discussed whether students who have aged out would be eligible to receive those.
Okay, thanks. Another question in terms of ESY and how that gets written for a student who has an IEP, the IEP, is that a separate document? Is it together? Or is that a local decision? How does that work for the ESY part of an IEP?
So generally, extended school year services, there is a page in that standard IEP format that goes through the checkbox of whether or not a student is eligible for ESY. So there generally is a placeholder in the program and software that schools use for ESY services. And again, it's making sure that the details of what those services are going to be are spelled out sufficiently enough that everyone kind of knows what the game plan is.
This is the last question I'm gonna pose for tonight. And then again, if your questions did not get answered or they're very specific, you can always contact PTSI or DLCV directly and we can work through those with you. This question is asking about those, sorry, I lost my place here. So COVID recovery services again. And can it cover, is it just one area of a student's need or can it cover multi areas?
It can cover multiple areas. So just to provide, I think the best way to answer to this is to provide two different hypotheticals. You may have a student who wasn't able to access physical therapy in the virtual learning environment. Maybe they tried some virtual physical therapy exercises and that it just wasn't working. They could get COVID recovery just for that very specific aspect, physical therapy. On the other hand, there may be a student who, due to their disability, could not focus in any of their classes when it was virtual, which would encompass a wide variety of services and coursework over an extended period of time. And that would be a more expansive and broad COVID recovery service plan. So really, it's going to, again, be looking at what were those gaps in educational services or areas where a student wasn't able to progress as they should because of COVID. And then what do we need to do to make up for that lack of sufficient progress?